Are there other ways that they can do some checks without applying for certificates?
Well, with a lot of the authorities, they do expect you to order the certificates, and if you speak to any of them and they're going to provide you with any information, ideally you'd want that in writing just to double check that everything is correct, and should something pop up later on, you've got something there as a backup to prove what was previously discussed. So
that's right. The certificates give you certainty, but they also cost you money. So you're balancing one with the other. The Vic Road certificate, for instance, if you've got a current Melways, not like my 2004 volume that I was looking at to get here today, you'll be able to see whether there's a freeway proposed through the house you're buying or around the corner. And we're not far from Eastlink. So for many, many years, the proposed Eastlink reservation was shown on Melways. So as a purchaser, I might decide, well, I know the area, it's not going to have a freeway through it. I don't need to get a certificate from Vic Roads for that to that effect. But if I'm a mortgagee who's selling, I do, because I can't take any risks at all.
So what happens if you don't get any certificates at all and you just do a transfer?
Well, from a vendor's point of view, when you're doing a vendor's statement,
yes.
Yeah, you don't have to, right?
From a purchaser's point of view, and acting on behalf of the purchaser, it will create panic stations. It's taken a risk. Obviously there are the initial certificates that regardless you need to order in order to complete the adjustments. And so I tend to also order building permits because we have come across a situation where previous conveyancers haven't ordered building permits and notices, and one example was one of our clients had purchased a property where previously there was a notice placed on in regards to the vendor's veranda, and the vendor purchased the property without doing that particular certificate, didn't realise there was a $6,000 fine attached notice from the council. Fortunately for our client, we had done that search and we had to make sure that the vendor had made all the arrangements to correct the pergola as well as pay that outstanding fine. Otherwise, if we had settled and not done that check, that $6,000 would have been passed on to our client to pay. So there are some risks in not doing...
From a risk management point of view, our firm our practice is also to apply for certain essential certificates that we think that is required, that is needed before the settlement.
Correct.
And whatever the Section 32 discloses, and specifically if a certificate is more than 3 months old, we usually tend to apply for those certificates. We think that's required.
Yes.
I'd agree with that risk management principle, but still bearing in mind that there is no compulsion for these certificates to be provided by vendors. It's simply one way for them to disclose information. And a certificate, whilst I agree that a 90-day sort of review period is good practice, it is not out of date. It's not ineffective, even though it might be 3 months old. So that the Vic Road certificate that said there's no freeway might still be no freeway. But I agree that this is all a question of balls in the air and managing your risk. And if something is 90 days, then you might think about reviewing it. But it all also comes down to a question of cost. There's no question at all that conveyancing is a cost-sensitive product. And if you say to a client that my costs will be X dollars and I'll spend $500 getting every certificate under the sun, you may find the client saying, well, look, I'm not so sure that I want all those certificates at that cost. And yet you don't have a lot of time and a lot of ability to explain all this to a client at the beginning of a transaction. So it really largely does come down to experience and making judgments at the time.
That is the practical reality, isn't it?
Dependent on the type of property.
Yes, yes. And usually it is again our practice, and in relation to costs, we would normally estimate about 200 to 300. Sometimes, as Russell says, it can go up to 500 depending on the circumstances. But our opinion is usually for that amount, like $200-300, it's worthwhile applying for certain certificates that we think that should be applied. That's just our personal opinion, not legal opinion.
Russell, you mentioned some time periods like the 90 days. If you are applying for certificates, when should you do that?
The vendor ordinarily will provide some number of these certificates, and certainly the outgoing certificates. And we're going to talk about adjustments shortly, and that you must work off certificates for that purpose. Right? Well, 99% of the time you must work off certificates. So generally speaking, there'll be certificates provided at the outset of the transaction. It would not be normal to check those certificates, such as the Vic Road certificate, to get another one during the course of a normal 60 or 90 day transaction. Right? We would normally rely upon those. We would update the council and the rate information, the outgoings, and owner's corporation, which is another certificate that we have to get if there's a owner's corporation, because we need to know what the amounts are at the settlement date so that we can undertake this adjustment process. So they're the ones that you would really update. And that's generally done simply by ringing the council, advising them of the certificate number, because they've already had their money, and then they just give you an update. It would be quite unfair that they would charge a second time.